Good morning, good morning, good morning, amazing, Leonard, and depending on when and where you're watching, good afternoon, good evening, good night, and hello, how are you? We have Massachusetts things to talk about today. Lots and lots and lots of Massachusetts things to talk about today. I was chatting with my co-host before we got started, but he is just trapped under a cat. So we've got bring your child and your cat to work today. So Griffin and George are just G are just hanging out for a minute because they wanted to, and it's summer. So now that G's cat trapped, there's not much he can do. So for those of you asking, how is George doing? Well, he's tolerating alternative humans. Are we leaving, Griffin? Yeah. All right. And we're out. George and Griff are out. All right. So good morning, everybody. We are going to go to Massachusetts today to finish up all of the things that we didn't get to finish up last time. And we have a new order from the court regarding discovery. Your Honor, hey, it's me. I'm the problem. It's me. Sometimes, Your Honor, you have just made things so much more difficult in this case. And we have a quick, or at least I think it's quick, status conference that we have not covered yet. I have not seen it yet. And so we're going to do that. So that's what we're up to today. We're going to Massachusetts. We're going to see what's going on with all this discovery, the things that we didn't get to finish last stream because so much was going on. And that's what we're doing. I know all of you are like, G has gotten so tall. They do that at this age. Every time we buy him pants, they're all of a sudden, they do that at this age. They really do. He keeps getting taller. And there was a day that my mom called and he was in the background and she's like, wait, is that Travis? I'm like, no, that's Griff. Yeah, no, I know. We're at that age. We're at that age where everything's a skill issue. Growth spurts are massive and everything is just different. It's fantastic. The sass is a lot. It's fantastic, but it's sassy. But the skill issue is just hilarious. So, are we ready to go to Massachusetts? Let me know where you're coming in from, what you're drinking. I've got coffee. Emily, is it late for coffee? It's the first one of the day, so it's never late. For coffee. It's fantastic. Anna in the chat said, Emily just moved to Utah. I was in Summit County yesterday. I thought of you. Oh my God. When you go to the Maverick in Draper, you have to come back and let us know. I was this way when I first moved to Tennessee because there were things I listened to like 90s country music growing up, but like Southern California, not like South Southern. And so there were times where things from the country music would happen and I'd be like, oh, Shoney's is a restaurant. What? And then I would be like, wait, Grundy County's in Tennessee. You want to know how I know? Because in Tennessee, all the license plates have your county at the bottom of the license plate. So I was driving and I saw a license plate with Grundy on it. I was like, oh, wait, no way. And I called Judge Abby because Judge Abby is more of a Tennessean than I am. I called Judge Abby and I was like, Judge Abby, Grundy County's in Tennessee. She's like, I'm aware of this. And I'm like, I was not. She's like, well, where did you think Grundy County was? I'm like, I didn't really think about it. I don't know. Could be Tennessee, could be Kentucky, could be Texas. I don't know. It's a song. They never really specify what state the county is in. It's just the Grundy County Arch. Anyway. And then I was shooketh to learn that there was also a coffee county. And I was like, well, I'll be damned. There's also a coffee county. Look at that. So again, I was delighted. There are things I continue to be delighted by. And I'm just like, oh, wait, that all makes so much more sense now. She's like, I bet it does. I bet it does. I'm like, yeah, it does. So I know when we drove through the Chattahoochee National Forest for the first time, I was singing at the top of my lungs because way down yonder on the Chattahoochee, I was so excited. I was so excited. And my kids are like, what's happening? And now Travis also gets Chattahoochee stuck in his head. And he's just like, but it just sticks in my head. I'm like, I know. And I still know every single lyric to Grundy County Auction. She's an 8, she's a 9, she's a 10, I know. Hey, law nerds, are we ready to get set? The whole chat is singing Grundy County Auction. Right. For those of you that are like, Emily, what are you talking about? 90s country, like all 90s music, is just a 10 out of 10. Is a 10 out of 10. I love me some 90s country. Are we ready to go to Massachusetts? Emily, are we going to sing all of the music and just avoid all of the law? No, not today. Not today. We gotta get through discovery so we can move on. We gotta be able to move on. So, law nerds, are we ready to go to Massachusetts? Mm-hmm. And I said, hey, pretty lady, won't you give me a sign? I'd give anything to make you mine, oh mine. I'll do your bidding and be at your beck and call. Emily, it's too early. No, it's not. Never seen anyone looking so fine, man. I gotta have her. She's a one of a kind. I know. Let's roll the intro. Let's get to court and do the things. Emily, would it be more fun to have a sing-along than do this? Probably, but we're going to Massachusetts. We're going to figure out what this judge is doing with discovery. I'm already nervous because I already hate the premise that we're walking into. The premise that we're walking into is, hey, lawyers, there's discovery rules. And I've decided that more discovery rules are needed because I say things like a subpoena has to mean something and then don't do anything about it. And then I'm shocked when things just don't happen. Who could have ever anticipated that? You know what this judge needs? He needs a good stint teaching like 5th grade. Go work with some 5th graders and you're going to learn real quick how specific you need to be. Go spend a couple weeks at a junior high and you'll learn. Emily, are you comparing lawyers to junior high school kids? Look, man, I'm just saying, you got to be real specific and you got to hold them to it. Otherwise, they're just going to keep doing what they're doing. It's not that different. Let's go. Emily, is that in the right place? Yeah, it's fine.
Is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
All of the teachers in the chat are like, that's facts. Right, because as a teacher in the chat, you absolutely know that if you lay down rules and then don't enforce them, chaos ensues. And that feels like what's happening in court in Massachusetts in O'Keefe versus Reed. The court keeps saying a lot of things, but not actually enforcing anything. And when there are times that the court's like, well, you've got to go do your deposition, the court then has set it all up in a way that everything just kind of falls apart, like we saw with former Trooper Michael Proctor's deposition. And then really, the day that the court called all the lawyers in to yell at them, but then wouldn't address the underlying facts, it really just blew my mind. Because again, why not, if you're worried that someone is leaking something, why not just have a sealed hearing? If it's about a sealed matter, a sealed hearing is appropriate. So it seems to me that the judge wanted this to be a public hearing and scold all the lawyers, which also doesn't seem helpful. Second, why not inquire from the lawyers? He asked everybody to send signed declarations that they didn't leak the information. And it seemed that the judge was focusing on reacting to being mad that somebody may have violated the order versus trying to figure out where the misunderstanding was and then following up with the lawyer who brought that to the court's attention. Because that doesn't seem to have happened at all. And that really frustrates me because you would think we are trying to figure out what happened here. And it seems that the judge is not interested in figuring out what happened, but just wants to yell at everybody. So I am exhausted with it. And the all bark, no bite is my least favorite kind of a judge because then they just like yell at everybody and then nothing changes anyway. If you're going to yell at people, at least do something about it. But it just creates unnecessary, well, spectacle, which he was so critical of. And it's like, Your Honor, a mirror, Your Honor. We are creating the drama. Who in the chat just said, am I the drama? Gray space. Yeah, exactly. What, me? Am I the drama? Yes, you. It's you. You're the drama. It's you. All of the drama. Creating the drama is the drama. It's so much. So, as a quick background of how we got to what we're covering today. Sorry, that was my door, and it actually scared me. You saw that, obviously. It didn't get closed all the way, clearly, when Griffin went scooting out. But we started with the premise that more discovery rules were needed. All of the discovery rules exist. There are tons of discovery rules. There are rules that the lawyers have to follow. But the court, the day that he yelled at everybody, July 1st, and then told them all to have a happy 4th of July, the day that the judge yelled at everybody, he said that he wanted them to agree upon an order that allowed for more stringent sanctions. If I'm a lawyer, I'm sitting there going, I'm not giving you more opportunity to just wild out, especially after the judge gave the lawyers no opportunity to be heard about the supposed leak of information. Am I going to give you a shortcut to cause more problems? No. So the judge asked the lawyers to come up with a solution on their own, and if they didn't, he would craft one for them. The rules have a bunch of different sanction options, and they have due process. There are rules. Just enforce the rules that exist. But no, he wants to create special rules. Look, man, this isn't a game of Uno. You don't get to play like house rules. And I don't care that official Uno says you can't stack like a draw 2 on a draw 2. House rules. This isn't house rules. It's court. There are rules of civil procedure. Just follow the rules. There is no need to add any more. So, the judge has proposed a discovery order and then asked the lawyer for feedback. And so then all the lawyers gave feedback. So we're going to look at the judge's proposed order, whatever. The judge's proposed order, the lawyer's response to that order, and then the order that he actually made. And we'll see. We'll see what it is. Because what are we doing? Like, why make extra rules? Why not just enforce the rules that exist? Why? Just do the thing. So, Emily, are you pre-annoyed? This whole circumstance seems like a needless waste of time and an exercise in futility. So yes, it annoys me. I think it could have been handled more easily. I think the court could have handled this more clearly. I don't think special discovery orders are needed. And I don't understand why the court just insists on wilding out on everybody. So we're going to start with docket 157. It's a very good place to start. So we're going to start with docket 157 and take a look at this because why not? Docket 157. This is this is from July 10th, proposed discovery order. On July 1st, I invited counsel, nay, you instructed counsel. I invited counsel to come to an agreement to hold private personal information in confidence. He said more than that. He said, I want additional sanctions. Right. I invited counsel to come to an agreement to hold private personal information in confidence. And all the attorneys are like, we already did that. Sure. On July 6, 2026, I stated that if no such agreement is filed, before 4:30 p.m. on July 9th, I would issue further orders I deem appropriate. Prior to issuing any such order, I invite the parties to provide comments on the following draft language. So he's just asking everybody to reflect upon the draft language. Quote, deposition testimony taken in this matter in the form of video or audio recordings or written transcripts, including private personal medical information learned at any such deposition or through discovery, shall not be disseminated and shall only be used for purposes of this case or McCabe v. Reed. Each party is requested to provide written comments, parentheses, 1 page and no more, to the above, the court, on or before 3 p.m. Monday, July 13th. As to other pending actions, although the parties to any related matter are free to agree to such limitations, I will not enter an order in a matter not assigned to me. Because there is a panoply of litigation. This court is only assigned the defamation case, McCabe v. Reed et al., and the wrongful death case, O'Keefe v. Reed et al. So, let's take a look at the attorney comment, because at this point, the judge is just making work for the lawyers that doesn't need to exist. No one needs to do, why does anyone need to do this? And remember, last time we talked about Reed, we looked at the letters to the court from Reed's attorneys saying, hey, Your Honor, all of this is based on statements on Twitter that you thought came after an email was sent to the court and to counsel, but those all happened before. Nothing was leaked. Can you please lift the discovery stay as to former trooper Michael Proctor? And the court said no. So we still have a discovery stay as to former trooper Michael Proctor, which I think is a punitive sanction because there's a discovery deadline coming up like TikTok in just a couple of weeks. And the court is, while they are supposed to be doing all their other stuff, the court's like, do this now. Because for the next 4 weeks till the discovery deadline, you need to do this. This is not an invitation. This is, well, a directive. So, what did the attorneys do? Well, the attorneys responded, all of them. So we're going to take a look at each and every single one. Why? Well, because I'm actually real curious what the attorneys had to say and what language they want in there. And also I'm curious if any of them is like, the model rules say this, so can we just do what the rules say, please? So the first one I pulled up is from July 13th at 2:15 p.m. Defendant Waterfall Bar and Grill. Response to proposed order. In response to the court's proposed order, paper number 157, the defendant has no objection to the court's proposed order as drafted. Again, the hospitality department, the defendants, the bars, Waterfall, CF McCarthy's are like, whatever. Can we be done now? Like, whatever. Just whatever. Can we be done? It's fine. Can we not? Yeah, we don't object. Let's take a look at what CF McCarthy said. I wonder if it's basically the exact same. I'm guessing it's at least along those lines. July 13th at 2:05 p.m. Defendant CF McCarthy's. In response to the court's proposed discovery order, paper number 157, the defendant's C&C Hospitality, DBA CF McCarthy's, state that they have no objection to the court's proposed discovery order. Your Honor, we don't care. We don't care. Can we just make our motions to dismiss? Can we get past discovery and just make our summary judgment motions, please? Because if the people who know Karen Reed couldn't perceive or didn't perceive that she was overserved, then how are the bartenders to know she was overserved? We're just waiting so we can go. We would like to go, please. Can we leave? Can we be done? So this is from attorney Lincoln Rose, who generally just sits there and is like, thanks, Your Honor. The bar defendants are just like, no, we have nothing to add. Thanks. We're just following them. We got to be here, but we're just going to follow them. Yeah, we're good. No, we're good. Thanks. Leave us alone. just let us be. All right. The next filing, docket, what is this? Docket 160. This is a request for clarification from plaintiff. So this is coming to us from attorney Diller. Didn't the court say, wait, I moved the wrong things. Hold on. I was trying to move the docket number, and I moved, what did I move? Not that. All right, here we go. Emily, Diller's motion is fighting to just not be put up on screen. Apparently so. We're already girding our loins. This is from July 13th at 11:44 a.m. I think this was the earliest one filed. So there's that. Single spaced. Didn't the court say 1 page? Plaintiff's request for clarification on proposed discovery order paper number 157. It's pretty close. Plaintiffs appreciate and support the court's interest in protecting the confidentiality of private, personal, and medical information obtained during discovery. In order to effectuate the court's intent to strike the appropriate balance between protecting the privacy rights of parties and witnesses on the one hand and not to impede on plaintiff's ability to fully develop a discovery and discover evidence on the other, plaintiff respectfully requests clarification as to the scope of the proposed order. Hey, Your Honor. What do you mean? Also, I love that he mansplained the court's intent to the court. The court is intending to strike the appropriate balance, right? The proposed order prohibits, quote unquote, dissemination of the entirety of every deposition without exception. Plaintiffs are concerned about 3 potential implications. Number 1, plaintiffs intend to use Ms. Reed's deposition testimony and that of other witnesses in future depositions for the purpose of establishing credibility issues. Plaintiffs believe that the court order should not limit a party's ability to use deposition testimony while deposing other witnesses. Interesting. We would like to show other witnesses Karen Reed's deposition and then ask them questions about that. We would like to question other witnesses about what she said to establish credibility issues. By credibility, they mean her credibility. 2, not every potential witness in this case will be deposed, and plaintiffs similarly will need to ask witnesses about statements made by Ms. Reed and other witnesses in deposition. The court's order should not hamper plaintiff's ability to investigate the veracity of Ms. Reed's sworn testimony outside of the deposition context. Your Honor, we need to be able to tell the other witnesses what she said so we can ask them if she's being truthful. Okay. 3, finally, the language could be construed to prohibit the filing of evidence in motions before this court. Plaintiffs seek clarification on how the court would like the parties to handle public filings, specifically whether the court requires the parties to file under seal all deposition transcripts and all medical information, including information about Ms. Reed's medical condition, central to the intoxication issue in this case, used in the prior criminal trials, argued by Ms. Reed's criminal defense team, and disclosed publicly in the media by Ms. Reed and or her criminal defense team. Well, it's just like, so hey, there are all these problems. And see, the rules of civil procedure and the rules of discovery take these all into account. But I understand where plaintiffs are coming from. So if we want to file motions using things we learned in deposition, can we not do that? If we want to ask a bartender about something, can we not do that? If we want to use these in any way other than in trial, can we not do that? Like, can we not use these at all? And I understand the frustration here. They go on to say, plaintiffs respectfully request the aforementioned clarification of the proposed order to assist counsel in conducting discovery efficiently while remaining fully compliant with the court's order. I'm not mad at that. It actually is like, but Your Honor, you haven't considered this and this and this and this and this. What would you like us to do about all of that? Like, we still need to lawyer. And how can we still lawyer with this restriction? I don't disagree with Diller on this. Fair clarification. But also, Diller's in the situation where it's like, God, this has gone too far, I would imagine. This is my just speculation. Because the fight with Proctor, now Diller has kind of chimed in on the Colin Albert fight, but the fight over Proctor, the plaintiff's attorneys have pretty much stayed out of. And so I don't think they want the Proctor fight to create difficulty for them. That is definitely not what they're going for. So they also aren't confident, I think, in the way that the judge is going to interpret these things. And I understand the concern with the court. Because if you're these lawyers after July 1st, and maybe even before, but after July 1st, do you trust that the judge is just going to like wild out on you? I don't. So I wouldn't. I would have grave concerns. So that's what the plaintiffs had to say. Let's see what the defendant Reed's attorneys have to say. Because I understand the issues. Hey, this could be a big problem. Can we not? Can we just not? Also, Diller with the single spacing. Reed's team has tackled that problem differently. So, this was filed on July 13th at 10:19 a.m. Emily, why are you telling us when they're filed? Because I'm interested in which ones were filed first. I'm just curious. Defendant Karen Reed's response to proposed order. And then instead of putting it on page 1, they just took an entire page on the next page, double spaced. It's one way to do it. So they have found a different way to tackle the court's like, 1 page, please. Defendant Reed, there we go. Defendant Reed respectfully responds to the court's July 10th order. I wish they would have said invitation. What? Like a party? The court's July 10th order seeking feedback on proposed language restricting use of deposition testimony. Reed believes that the court's proposed language is overly and unnecessarily broad. Okay, here's the thing though. I know a lot of you don't want to find yourself agreeing with Diller, but do you see the difference in approach? Do you see that Diller was just like, in all deference to the court, and I understand that the court's very, very valid, very noble, very, very wise goal is to strike this balance. Diller came in with, Your Honor, you're so correct. You're so correct, but also, what about these 3 problems? So it came in with, yes, Your Honor, you're right. We agree with you, but also there's these issues. Can you just help us out with those? Reed's team comes in like a wrecking ball and is just like, no. So the approach is a bit different. Also, the ongoing relationship with the parties seems about different, but Diller is just like, hey, Your Honor, so these issues, Reed's team is like, unnecessary. They're just head first into the, this is shit. What are you doing? So I think with this court, and I don't know if we're past the point of no return with this. I don't know if it would even help. But this court does not seem to do well when you just try to butt heads with them. It seems that the court does well with, hey, I understand where you're coming from, but we would like more guidance on this. It does not seem that the just straightforward, in-your-face approach goes well with the court. And the contentiousness just keeps ramping up. And so there's time that Reed's team, I think, would do well to soften the language, especially in a motion like this, where the court has proposed language. State your concerns. Hey, the court's goals are concerns that it can be construed like this. But when you hit the court head on with overly and unnecessarily broad, the court just keeps getting frustrated. So, a lot of you were like, but the court's been rude to them. Right. But they're the lawyers. They have to work with the court to get what they want. The court doesn't have to work with them. That might seem unfair, but that is the reality of being the lawyer in court. You have to play to the referee that you have. They can't yeet the ref. You have to play to the referee that you have. And the team that does that better is going to get better results. That is your job as a lawyer. And they have to play to the court that they have. And headbutting with the judge does not help here. So this is just an approach. But also, for those of you that are like, well, that sucks. It does. Lawyering might not be for you. It does suck. But all of you have had to deal with this in your life. Tell me you've not had a supervisor where it would be so much easier if you could just say, actually, no, that won't work, and here's why. And instead you have to say, I see where you're coming from. Actually, that's a good idea, but I wonder if we just slightly do this, if that would work better. All of us have had to deal with this in our work life, in our life, with friends, with family. We all have to sometimes modify the direct answer. Especially when you are communicating with a person who is in charge of the job you do, but has not really done the job you do, or has not done the job you do in so long that they have forgotten the job that you are doing and are trying to tell you how to do it even though they've not been on the field. Teachers have to deal with this all the time with admin that was never in the courtroom. Medical has to deal with this all the time with admin that's like, I don't even know. You guys have to deal with this at work. It sucks. However, the job of a lawyer is to get the best result for your client. And so it's really difficult when they're just butting heads. And they're just butting heads. So, but you guys know what it is. So coming out with unnecessarily broad is not going to help. It's just going to piss off the court the second they read it. And I understand that this might seem like a silly game to play. I point it out because to be an effective attorney is not just to know the law, it's also to know the audience. And telling the judge he's being unnecessary is just going to make the judge go, oh, you haven't seen unnecessary yet. Right. And then the reader will stop reading. At least stop reading with an open mind. Should it be that way? No. But we've seen this judge be super reactive. So, yeah, it's frustrating. All right. So the court is going to read this second sentence and just be like, Reed believes that the court's proposed language is overly and unnecessarily broad and would significantly prejudice her. Diller essentially said the same thing. The approach was just different. In particular, the court's proposed language would limit the use of, quote, all deposition testimony taken in this matter to this case and the McCabe case. That means that such testimony could be used by all non-Reed parties, plaintiffs, in the two cases against her where they have the burden of proof, but not in the two cases in which Reed is a plaintiff and has the burden of proof. There's a difference, though, with that for me, is that the judge does not have control over the federal case where Reed is suing and over the case against MSP and Canton. But I would imagine, and maybe the concern from Reed's parties or Reed's attorneys, is that if they ask the judge to be allowed to use those depositions in the other case, that he would say no. I completely understand the concern there. Completely understand the concern there. Because, again, the court said they didn't want to overstep into cases that they are not a part of. But I think that the court's core concern is that this all ends up on the internet. I think that's what the court's worried about, without saying as much. The Reed's attorneys go on to say that no rule restricts use of deposition testimony in this matter, and in fact, the standard evidentiary guidelines permit the use of prior deposition testimony in later proceedings as prior sworn statements. Right. The rules already exist, and this is narrowing the rules. And I completely understand the attorney saying, Your Honor, you can't narrow the rules on us. This is what the rules are. We're not agreeing to fight with one hand behind our back, essentially. Why would we? I agree with them on that. Again, I don't disagree with their position. I just think they might be better served by a different approach, but you guys get where I'm coming from on that, I think. Right? But I understand. Because I see you guys in the chat. I understand. Having to placate other people's communication styles can be exhausting. Especially when you're like, wouldn't it just be better if I could just tell you what needs to be done and we just like do it? Wouldn't that just be easier? Yeah, right. I wish that would work better. I wish that would work. I get it. But we're not restrained in this way. So why would we restrain ourselves in this way? That's just dumb, Your Honor. We're not doing that. It goes on to say, of course, the court has discretion to restrict use of specific confidential information where necessary. Not the entirety of the thing, but discrete specific information. They go on to say, but the court's proposed language would mean that any admissions or testimony obtained in this case could be contradicted in either of the other pending claims in which Reed asserts claims. I wish they would have said cases, but anyway, either of the other pending cases in which Reed asserts claims, but same. There is no justification for such restriction. They really have just come in swinging. There is no justification for such a restriction. Reed has repeatedly submitted uncontroverted evidence that there was no violation of the court's impoundment order, which is the stated reason for this proposed restriction. I don't disagree with them. However, regardless, Reed has proposed to the parties that all deposition testimony and all personal medical information be used only for the 4 cases pending regarding these events and not otherwise disseminated. That seems reasonable because Does that seem reasonable to y'all? I mean, that seems reasonable. That it be used for proper lawful purposes in the fleet of pending litigation, but not otherwise disseminated. If the court's concern is that this not end up all over the internet, then that seems to be constructed to do it. Plaintiffs have not agreed to this restriction. So, Your Honor, Your Honor, we've tried to sort this out, but the plaintiffs don't agree. But that doesn't make sense to me that plaintiffs don't agree. Because we just read what plaintiffs said, and plaintiffs said, we don't want this to be so restricted that we can't use it in this case. And it seems that defense is saying, we agree this should be used in all 4 of these cases, but not disseminated outside the case. Plaintiffs have not agreed to this restriction, but Reed remains willing to accept this restriction. If the court were to order such a restriction, Reed also requests that the court state that any party accused of a violation of the court orders that any party accused of a violation of the court's order will be provided with notice of such accusation and the opportunity to be heard before any sanctions are imposed. Right. Excuse me, Your Honor. See, the reason that like all of the sanction provisions have like a whole lot of due process is so attorneys know what they're accused of doing before they're punished for doing a thing. And so in this case, the court does not see themselves, and this is the problem, is the court does not see this circumstance as Reed's attorneys being punished in any way. I disagree with the court on that. I agree with Reed's attorneys on that. Because Reed's attorneys have been forbidden from doing any further discovery as to former Trooper Michael Proctor. And who is the person that hurts at the end of the day the most? Reed. So I understand why the court's saying, but we didn't sanction you. And Reed's attorneys are saying, yeah, but you did though, and you didn't give us any opportunity to respond. And the court's like, well, right, it's not a sanction, so you don't have a right to respond. Right, but you put a stay on discovery, which impacts us the most, so that is in fact a sanction without an opportunity to respond. Right. So with that, do you want to see what the court does? Do you want to see what the court does? Let's see what the court does. All right. All the attorneys were like, hey, can we handle this? Well, the plaintiff was like, we don't want to be so restricted. The defendant was like, we'll restrict it to these 4 cases, but we do think it's overbroad. And the bars are like, whatever y'all decide. Whatever y'all decide. Y'all, whatever you decide, we're fine. The bar attorneys, can you imagine just for a moment the attorneys for the bars looking at this fight from basically the sidelines and just being like, it's fine. It's all fine. It's all fine. It's great. A number of you asked who wrote Reed's response. That was Rosenberg that signed it. Let's look at the court's order. This is docket 163, filed on, well, the court says it's filed on. I didn't see it on the docket for a few days. Filed on July 15th, 2026. Then again, I was also traveling, so it is what it is. And then from here, we will go to the hearing that we need to catch up on. Cool? Cool. Let's swoop. Let's see what the court eventually did. Discovery order. This order is based on my plenary authority, which means his kind of granted authority. Like the court has the authority to handle discovery. This order is based on my plenary authority to control, manage, and oversee the conduct of discovery. Excuse me, Your Honor? Could you do that, though? Because it feels like we're just mucking around with it. And the court cited Buster versus George W. Moore, Inc., stating, in general, discovery matters are committed to the sound discretion of the trial judge. And citing other case law, Cronin versus Strayer, saying, we remind judges that the scope and timing of discovery is within their discretion and that the prevention of discovery abuse is significant justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. Well, we see how the court feels about it, don't we? The case law that the court has chosen to cite indicates exactly what the court thinks. The court is citing case law that reminds the court to kind of take the reins and make sure that there are no abuses of discovery, and that they should not hesitate to exercise appropriate control over the discovery process. But when the court had the opportunity to exercise control months and months and months and months ago, the court just kept kicking the can down the road, and it never got dealt with. Brandy B in the chat said, why do I have Cartman stuck in my head screaming, respect my authority? Right. It's exactly that. Hold on. I think we've got Cartman. I'm pretty sure we have Cartman.
Respect my authority!
Right. Because it feels like there is a lot of foot stomping and not a lot else. So, continuing on. The court says this matter was specifically assigned to me on November 14th, 2025. In the 8 months since then, I have been presented with various motions to compel, motions for a protective order, and motions to quash. You told them if there were any discovery issues that they needed to file it and not wait to try to sort it out. You told them that they were waiting too long to file things and that the court was there. And then when attorneys said, well, we were trying to work it out ourselves, the court said, and where has that gotten us? File it. Let's move it along. You told them to do this. We watched it. Okay. The court says such motions have raised issues as to confidentiality of medical records, confidentiality of personal and disciplinary records, and possible public dissemination. I like this mug. I have to put it down. I have to take things out of my hands. What? Even after we read everything that had been presented to the court is still doubling down with possible public dissemination and or posting to social media of deposition materials and other privacy-related issues. Girl, be so fucking for real right now. Okay, well, we know where the judge is at. We know where the judge is at. There's a footnote. What are we doing? Oh my God. Okay. They say, I'm going to go through the full sentence and then we'll look at the footnote. The court says such motions have raised issues as to confidentiality of medical records, confidentiality of personnel and disciplinary records, and possible public dissemination and or posting to social media of deposition materials and other privacy-related issues. Footnote 4. A partial listing of such motions is attached hereto as Exhibit A. Okay, can you post the deposition materials that have been released? Because I haven't seen that. I mean, I don't go looking for random stuff on the internet because I assume most of it's probably faked. But are you talking about the fact that somebody saw Proctor outside? Because I think that's what you're referencing. But that's not deposition materials, is it? That someone saw someone in public. You know, shocking. It's like, I saw Emily at Dunkin' the day that the pumpkin donuts were released. Riveting. Obviously, they're the best ones. This is not top secret information. What are we doing? Okay. Continuing on. Many of the motions involve depositions of non-parties. I read the language of Rule 45B as to, quote, undue burden to include a non-party's right to privacy in certain matters. I don't agree with that. I don't disagree with that. I'm now mad. Do you see what happens to the reader when you start with whatever this is? Right. I don't disagree that using litigation to harass non-parties is not okay. Putting an undue burden on a non-party is not okay, but it's for the court to rein it in. Continuing on, the court says on June 29th, 2026, the court's not done. We're doubling down. How many pages is this? I didn't look before I started. All right, it's not too long, but we're doing this. We're retreading this ground again. We're repastorating this ground. Okay. On June 29th, 2026, having been advised of information that allowed for a reasonable inference of a violation of an order of impoundment issued by me, I issued an order, paper number 139. In my July 10th endorsement on a motion for reconsideration, paper number 156, I acknowledged subsequent information as to the time of the June 8th, 2026 post on X alone did not allay my concerns that gave rise to the order, especially given the content of a June 25th, 2026 post on X. So when the goalpost got moved, the court was like, fine, move the goalpost. So the issue was the June 8th tweet. And then the issue moved to June 25th, which was the Proctor stuff. So the goalposts move and the court was like, well, right. It keeps happening. So this litigation is stuck in a loop with this judge that is reacting to things seen on social media that none of these parties can control. Huh. What an interesting quagmire for the attorneys. That's got to be annoying to everyone involved. However, the judge can just stop that, but it's not going to happen. So, the judge says, I invited counsel to come to an agreement to hold private personal information in confidence but have been informed that, though the parties sought to agree on restrictions on dissemination, they have been unable to reach a unanimous mutual agreement. Prior to issuing the below order, I invited the parties to provide comments on proposed draft language, and I did receive and have considered certain comments. Oh, not all, just some comments. We've considered some comments. Great. Based on the above, the following discovery order shall apply in this matter. Quote, depositions taken in this matter in the form of video or audio recordings or written transcripts, including private, personal, medical information learned at any such deposition or through discovery, quote, protected information, shall only be used for the purpose of this case or McCabe v. Reed. English majors and non-English majors who are very good with literary interpretation, because lawyers will fight over this all day long. So sometimes I don't know how we would just read it neutrally. Does he intend, we're just going first sentence. Does he intend to limit deposition testimony to deposition testimony, including private personal information or private personal medical information only? Is he using that to limit the deposition testimony? So he's not saying all deposition testimony. He's saying deposition testimony that includes personal private media information, or is he using it more as an and? What do you guys think? Do you think he's limiting it and trying to limit the deposition testimony to only include deposition testimony that includes private personal medical information? Or is he saying all depo testimony, which also specifically includes? Some of you are saying that he's limiting it. Some of you are saying that he's not limiting it and that he is specifically calling it out. And this is the problem, right? So, and that's where the problem is with the way that it's written. Because I think we could argue with, both of us having, with all of us having room to argue. I think there's room to argue that the comma is intended to limit deposition testimony to only deposition testimony that includes private personal medical information. But I think there's room to argue that he's saying all deposition testimony, specifically deposition testimony that includes private information. So let's keep reading. I would argue that he's limiting it, but I see the concern and the argument that he's not limiting it. So I think he's going more old school because I think the comma helps limit it, right? But we'll see, because I see the argument both ways. And this is why lawyers get paid to argue over commas. All right. Exactly. My dearest Angelica. Exactly. You've put a comma in the middle of a phrase. Exactly. If we had just said deposition testimony taken in this matter, that includes personal, private, medical information in such deposition or learned through discovery, it would have just been so much more clear. You added a comma and it changed the meaning. Exactly. We're back to Hamilton problems. The court goes on to say this order is not intended to restrict the standard evidentiary guidelines permitting the use of prior deposition testimony in other proceedings as prior sworn statements, the use of prior depositions in other depositions in these matters, or the investigation of the veracity of any sworn testimony. So he's then also trying to limit it, saying we're not limiting the rules, but then why do we need this at all? SL1 MJ3 in the chat said, comma, chameleon. 10 out of 10. 10 out of 10. 10 out of 10. I'm going to finish this. I'm going to tell you a story about a gong in a minute. But anyway, 10 out of 10. This order is not intended to restrict the standard evidentiary guidelines. Parties shall adhere, and then the next sentence is, parties shall adhere to trial court rule 8 relative to the inclusion of protected information in any filings, including any motions for relief. So, follow the rules. Notice of any claim of violation of this discovery order will issue, and an opportunity to be heard provided before the imposition of sanctions. And then the court is quoting Campana versus Board of Directors of Massachusetts, quote, affords a judge broad discretion to impose whatever sanctions are just in order to ensure the discovery process operates efficiently. Footnote 5, the temporary preclusion on taking discovery from a non-party set forth in paper number 139 is vacated. You put it in a motherfucking footnote? In a footnote? You're the drama. You're the drama. He vacated the discovery stay on Proctor in a footnote. Your Honor, excuse me, Your Honor, am I just being trolled? I didn't realize that this was like an episode of Punk'd, the legal. This is it's giving law school where you're just like, sometimes the professors will grab important exam questions from the footnotes. But what are we doing? This is so silly. He vacated the stay on Proctor's discovery in a footnote. Oh my God. It is. It's just, I feel like I'm just being trolled by the court at this point. Emily, you're making it way too personal. No, not just me, us. We are being trolled by the court at this point. What are we doing? I don't think I've ever seen that. I don't think I've ever seen it at all. Just, what? Let's just do it in a footnote. It's so fucking dramatic. It's so dramatic. Why do this in a footnote? Oh my God. The footnote just makes it more dramatic. If he had just put it in the next sentence, it wouldn't be nearly as dramatic. This is so dramatic. Oh my God. The temporary preclusion on taking discovery from a non-party. He didn't even say Proctor. The discovery stay as to former trooper Michael Proctor is vacated. In a fucking footnote. This is just the drama, Your Honor. The drama. I don't understand. Emily, why is there a footnote? I don't know. Crazy Catless Lady said, wait, what is vacate? It means it's removing it. The judge is eliminating it. It has been lifted. The stay has been lifted. The order has been vacated. It's been removed. It means discovery may go forward. It's no longer there. It's like, have you ever been weather delayed at like a concert? And you have to wait until the lightning is no longer within like 20 miles or whatever the restriction is. And then And then the weather delay is vacated. And then you can go back to the venue and do the thing, or the concert gets canceled. It just depends on the thing. Yeah. So the vacate is the removing of it, but putting it in a footnote is so fucking silly. It's just so silly. What are we doing? What are we doing? All right. Good Lord. This is ridiculous. It's why? Like, I'm glad it's been vacated. I think that it's good that it's vacated. This is the way we're going about it. But this has been my criticism for a number of weeks now. Even when there's things I agree with, the way we're going about it, I don't always agree with. And the way we're doing this is it's just so silly. Well, I guess it's beyond a sassy footnote. That's an authoritative footnote. This is funny. Tina's art page in the chat said he declared yeetus deletus in the footnote. He absolutely did. I don't know what's happening. B. Josie said Judge is having brat court all by himself. Yeah, Judge is like, it's brat summer. I'm just going to be wild. It's just so silly. I don't understand. What are we doing? All right, sassy footnote. Here we go. That it really is a sassy footnote. By the way, you can go do discovery from Proctor again. It's fine. And now we're on to Exhibit A. Remember when the court stopped, I believe it was Diller who was getting ready to list his Festivus grievances again. And the court was like, you'll have time for that. Because Proctor Diller was getting ready to go through a list of like, and then this, and then this, and then this. The court has now put that in an exhibit. This is the court's Exhibit A that was mentioned in a prior footnote. This is the partial listing of the motions attached. These are the motions regarding confidentiality of medical records, confidentiality of personnel and disciplinary records, and possible public dissemination and or posting to social media of deposition materials and other privacy-related issues. Here we go. Here's the exhibit. Not exhibit in Thundercat, but here's the Exhibit A. Date. Start date. December 2nd, 2025. December 2nd, 2025, paper number 56, motion to compel Norfolk DA's office to produce data in response to subpoena. What's this have to do with? It's a motion to compel, but does this have anything to do with privacy? December 19th, 2025, paper 60. Defendant Karen Reed's joint motion to enter protective order regarding Norfolk DA's office protection or production. Joint motion. That means everyone agreed, Your Honor. Everyone agreed. December 29th, 2025, paper number 61. Defendant Karen Reed's motion to continue Sergeant Sean Good. Motion to compel Sergeant Sean Good to produce documents. April 8th, 2026, docket number 96. Defendant Karen Reed's motion to compel the town of Canton to produce documents pursuant to non-party subpoena. Yeah, Your Honor. And when that came to a hearing, I remember what Canton said. Canton said, we know we have to produce this, but like, can we do it not yet? This is how we got to Pretty v. Please. Because Canton was just like, yeah, but we still have like stuff going on with Sergeant Good. So can we just not do that now? We just like, Your Honor, it would super help us out if we could just do that later. Nux. So this is April 8th, 2026. Defendant Karen Reed's motion to compel the town of Canton to produce documents pursuant to non-party subpoena. June 5th, 2026. Michael Proctor's emergency motion for protective order. June 9th, 2026. Docket number 118. Plaintiff O'Keefe's motion to compel responses to plaintiff's supplemental requests for document production. June 10th, 2026. Docket number 119. Defendant Karen Reed's motion to compel the Massachusetts State Police to produce documents pursuant to non-party subpoena. Remember when MSP showed up and they were like, we couldn't find the email Our bad. I actually empathize with the attorneys for MSP because they're like, the notification system wasn't like notifying us. Can we like have a little more time, please? June 12th, 2026, docket number 124. Defendant Karen Reed's motion to compel Colin Albert to attend deposition and produce documents. June 25th, 2026, docket 132, non-party case participant Lieutenant Brian Tully's motion to quash subpoena and for protective order. June 29th, 2026, docket 141, defendant Karen Reed's motion to compel Nicole and Brian Albert, Jennifer and Matthew McCabe, Allie McCabe, and Brian Higgins to attend deposition and produce documents pursuant to non-party subpoenas. June 30th, 2026, docket 145, Plaintiff O'Keefe's motion to compel responses to plaintiff's supplemental keeper of records subpoena from Aidan Carney. July 6, 2026, docket number 152.2, non-party Lieutenant Brian Tully's motion for protective order governing deposition. There's a sampling of the court's motions. So, where are we at the end of July 15th? Well, the court decided that footnotes were fun and added a sassy footnote in his discovery order that lifted the stay on discovery with regard to former trooper Michael Proctor. Just threw in a footnote on the last page of the motion. Look, it's a joke in movies and media regarding lawyers in law school and reading the footnotes. However, it actually really does matter. But I don't think I've ever seen a court vacate a court order in a footnote, ever. I'm sure it must have happened. This can't be the very first time that this has ever happened. I don't think I've ever seen it. Because normally it's just an endorsement order. Like you would generally expect to see, because this court uses endorsement orders frequently, you would expect the court to just put an endorsement paper on docket number 139 saying, this order remained in place until the court vacated said order. As of this date, order is vacated. You would expect it to just be an endorsement order, but no, not a separate docketed item, not a separate endorsement order, a sassy fucking footnote in the discovery order. And then the court took what happened in the feedback from Karen Reed and from Plaintiff's O'Keefe and took that feedback and fashioned it into this order, though I still think there is some room to argue that the court is limiting this to not all deposition testimony, but specifically regarding, I don't know why regarding is weird, but specifically regarding private personal medical information, though I do think there's an argument that he's highlighting that, but means all deposition testimony is protected under this. We'll see how it plays out over the next month and if there are any concerns. But the court did indicate that, hey, we're not trying to limit the rules that already exist. Well, then is there really a need for this order? Because private personal information and medical information is already protected under different rules. And the court, most stunningly to me, within the court's order regarding discovery, the court acknowledged that there was more information about the June 8th tweet that the court launched the hearing on July 1st over, and the court acknowledged that there was updated information. Remember, that updated information was that when looked at on Twitter in the Eastern time zone, that tweet was hours before the motion filed by former trooper Michael Proctor's attorneys. And the court said that that tweet, well, he says it again in here. He says that that tweet had, allowed for a reasonable inference of a violation of an order of impoundment. I don't know where on the scale of like preponderance of the evidence to like beyond a reasonable doubt. I don't know where reasonable inference falls for the court. At the very bottom, we're at like a whiff. We're like down with a scintilla. And that's not going to be enough for sanctions. But the court maintained that he wasn't sanctioning any party, even though the discovery stay did impact at least one party that wanted to take discovery from Michael Proctor. But then the court adopted the moved goalpost and said that even though the court got new information about the June 8th post on Twitter, that it did not allay the concerns because there was content on June 25th. And we know from past motions that we covered previously that June 25th post was regarding Proctor and whether or not he had any distress at his deposition. And Reed's team also tried to address that, saying, well, this information is floating around Twitter. It did not come from the lawyers. And Proctor was in public spaces and people saw him. So the court did attempt to limit the use of deposition transcripts, but also said it's not limited beyond the rules. So, Emily, what was the point of all of this? Well, the court wanted to make known that they are still concerned about information being publicly disseminated, that they are very unfriendly to any information that may be publicly disseminated, that they are skeptical that that is happening, and that any rebuttal of, hey, that's not happening, the court doesn't seem to be super amenable to because the court is still concerned. There doesn't seem to be anything that's going to allay the court's concerns. So the court entered this discovery order and then in a footnote said, oh, and you can go ahead and continue your discovery from former trooper Michael Proctor. That's quite an order. That's quite an order from the court. And after this order was filed, they all had a status conference. So we're going to fly to Massachusetts and take a look at the status conference that happened the very next day. So all of the lawyers would have read this before they hopped into that status conference the next day. So let's go take a look at what happened. I don't know. You don't know. We don't know. I don't know. Let's take a look. Insert funny name here said, when was this order filed? The 15th of July. And we have a hearing from the 16th. So we're going to go to the 16th and take a look at that hearing. Let me get that queued up and then we'll fly to Massachusetts. I'll grab my notes real quick and we will see what happens at the status conference. On every time there's a status conference, we learn something new. So I'm not mad about it. And we'll see. So that's what we're going to do. The court has been scheduling these status conferences at like 9:45 in the morning, right before all the attorneys have depositions. The court said it was essentially their intention to keep these hearings brief by scheduling them 15 minutes before everybody has to be in another meeting. So the court's like, we're going to keep it quick because there's no room to go off the rails because we've got y'all have another hearing. So, are we ready? Are we ready to go? Let's go. Nildum Bonilla in the chat said, wasn't Proctor's depo on July 14th? It was supposed to be, but the stay was still in order, so it couldn't have gone forward that day. So this was not filed till the 15th. Right. This was not filed till the 15th. So even if it was supposed to be the 14th, it couldn't go forward that day. Because when Reed's team here, let's go pull it up before we go to the hearing. This is a great question. We're going to answer it. Because Reed's team asked for reconsideration and the court said no, that they would not reconsider. Let me find the reconsideration real quick so we can just close that loop. And then for everybody who's not mad yet, we can just renew your frustration. We can just renew your frustration. I'm literally not trying to rage bait the chat, but They asked for an emergency motion for reconsideration. That emergency motion for reconsideration was filed July 8th. We're going to take a look at that just real quick to answer this question with documentary evidence. The emergency motion for reconsideration filed July 8th by Karen Reed said all the things we just talked about, telling the court, hey, this is based on a faulty premise. Can we please be allowed to go forward with the deposition? The foundation upon which, and I'm reading from the motion, the foundation upon which the court relied to suspend Proctor's deposition was mistaken, and the court should vacate its order to avoid unnecessary delay in discovery, particularly where the second day of Proctor's deposition is already scheduled for July 14th, footnote 2. Footnote 2 says, Reed brings this motion on an emergency basis because the second day of Proctor's deposition is already scheduled for July 14th, and all counsel and parties have already planned for that date. It is particularly important to protect this scheduled date because Proctor previously asserted that he had limited availability. It would be unduly and unnecessarily costly and burdensome to force Reed to miss a previously scheduled deposition day because of the order, which was based on an incorrect premise. Were Reed to serve this motion via Rule 9A, the oppositions would not be due until after the currently scheduled date. Reed's counsel conferred with Proctor's counsel concerning this motion prior to filing it. So they went to the court, and we covered this last week. This was filed on July 8th. They went to the court and said, Your Honor, we have a date on the 14th. We can show you that the reason that you filed this protective order is based on not what you thought it was. So can we please, pretty please be allowed to depose former trooper Michael Proctor? And on July 10th, the court said this. And this is the teeny tiny print at the bottom here that is the court's endorsement order. I'm going to embiggen it so I can read it too. July 10th. I have been presented with a motion for reconsideration of my order precluding further attempts to take discovery. Actually, let me just do this. Let me keep this on screen. Let me pull up another copy of this so I can embiggen it so I can read it. Let's see. I know it's going to be a little difficult for y'all to read. I'm just going to grab this so I can read so I can embiggen it without scrolling it back and forth for y'all. But July 10th, I have been presented with a motion for reconsideration of my order precluding further attempts to take discovery from a non-party pending further orders of the court. An opposition and a reply. Ms. Reed's attorneys are reminded of the provisions of Rule 9A, that a reply memorandum is to be, quote, limited to matters raised in the opposition which were not and could not have been anticipated and addressed in the moving party's initial memorandum. CEG last week when I yelled about that because Reed's moving papers addressed the June 8th tweet. The opposition from Proctor addressed the June 25th Proctor's deposition day tweets. And then Reed's party addressed that in the reply. And then the court's like, a reply is just for things you couldn't have anticipated. And I'm like, but they're moving the goalpost unless there's things that we don't know about that happened where the court told them to address this. The motion, this is continuing on in the order, paragraph 2. The motion misstates what I said. What I said was, that's a direct quote. What I said was, quote, orders of the court have been violated either directly or at the very least in spirit. I did not say what is stated in the motion, quote, that an attorney with an appearance in this case had violated the letter or spirit of the rule. I also did not state on the record that, quote, I have stayed the second day of Proctor's deposition, but rather stated that, quote, because the disclosure of sensitive private information, because of the disclosure of private sensitive information, I temporarily stayed further discovery of the non-party. I acknowledge the information in the motion as of the time of June 8th, 2026, or the time of June 8th, 2026 post on X. However, such information does not allay the concerns that gave rise to the order, especially given the content of a June 25th, 2026 post on X. The motion for reconsideration is denied. So the court said in his order, no, you misquoted me. That's not what I said. And no. And then lifted the stay the day after the second day of the deposition was supposed to be scheduled. So there's that. I'm glad you asked the question, chat, because chat is bae. And for those of you that did not see my coverage of this previously, how you doing now? How we doing? All of you are like, oh my God, he is the drama. It was like June 8th all over again, where the court came in for the emergency motions and was like, let's kick it to the afternoon. So they missed an entire day of deposition, and then the court's like, go to deposition tomorrow. And then the next day, all the lawyers are like, we can't just go tomorrow. Right. So then the order lifting that stay was the next day. It was filed the day after that scheduled July 14th date. So on July 10th, he denied it. July 15th, he lifted it. So now they're going to have to find another day to do Proctor's discovery. Emily, that seems dramatic. There are judges who will remind you that when they say jump, your job as a lawyer is to say how high. Emily, that seems awful. Yeah, it does. It does seem awful. And what's even worse is when we look at cases where people accuse judges of doing that are clearly not doing that. And then we see judges that do that. And we're just like, see, this judge is actually doing it. Like we read Sarah Boone wilding out about Judge K. And we're like, that's absolutely not what Judge K was doing. Or we look at that motion by Corey Richan's attorneys being like, well, Judge M is doing this and Judge M is doing this. I'm like, girl, you don't even know the half of it. Do I have a judge in Massachusetts for you? Because can you imagine this judge and Attorney Nestor? Could you imagine? Could you imagine what that would look like? Oh boy. All right. So July 16th, they all have a status conference that we're going to go to now. Yeah, status conference. So let's take a look at that. We did not fly to Massachusetts yet. So let's fly to Massachusetts. Please leave your seatbelt fastened at all times in expectation of turbulence because we're flying to court in Massachusetts. So it's already been bumpy. I expect it will continue to do so. Let's go to court. Attorney Shipley, I apologize. I did not mean to just, move my face. Hold on, chat. Should we just move me into the blank space? I'll write your name. Let's just do that. Hold, please. We'll just join the Zoom call. Does that work for everybody? There we go. Almost. Somebody just sing the Brady Bunch theme song with me and we'll just do the thing. Or Hollywood Squares, you guys pick. You guys pick which one works. There we go. We're just going to do that. All right. And I'll write your name. Let's go to court. This is from July 16th. EDB was traveling. We're going to go to court. This is a status conference, actually not a hearing. We're just going to put status. You know what we mean. All right, everybody. Shall we Shall we see what happens? At least it's a Zoom call and they didn't all get dragged into court. So I guess that's better. But we're just like, there we go. Full Brady Bunch. Let's go to court.
Good morning, Your Honor. May I proceed?
Go right ahead.
Good morning, everyone. The matter before the court is Civil Action 2483 CV 00692. Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as DNF McCarthy's et al. Your Honor, all parties are present via Zoom. For the plaintiffs, we have Attorney Daniel Buck and Attorney Mark Diller.
Sorry, Attorney Shipley.
For defendant DNF McCarthy's, we have Attorney Tamara Holstag. For defendant Waterfall, we have Attorney John Dealey. And for defendant Reed, we have Attorneys Sarah Shipley, Damon Seligson, and Aaron Rosenberg.
Morning, everyone.
Morning,
Morning, Your Honor.
Who would like?
Good morning.
No, we've got Aaron Rosenberg and Lincoln Rose. So A. Rose and L. Rose. I think it works. I do appreciate that Rosenberg's always smiling. Are we smiling at the ridiculousness, or because I imagine that's just where we're at this point.
Who would like to start out? Well, why don't we start with the plaintiffs? What do you have to report relative to discovery and depositions?
12 depositions have occurred, and there are depositions on the calendar every day for the duration of the discovery period.
Excuse me, Mr. Buck, what's your coffee order? I'm really curious. What are we drinking? I want to know. 12 depositions have been done. That's helpful. Guess what, Your Honor? They could have done one on the 14th, but there was still that order in place, so they didn't get to do one. They didn't get to do one on the 14th. That must have been really, really difficult. Something just fell very loudly. I'm going to put this on. You're going to see me talking. I'm going to mute myself real quick just to make sure that everything's okay.
What do you have to report relative to discovery and depositions?
12 depositions have occurred, and there are depositions on the calendar every day for the duration of the discovery period.
Okay. Any issues having people appear?
Yes.
Your Honor.
There was supposed to be a deposition on the 14th, and there was still a stay in place. So yeah, it was real hard to get everybody to appear because of the court's order. But I digress.
For Ms. Reed, this is Attorney Rosenberg. We've obviously filed a number of motions, but I don't believe there are any that are either outstanding via 9A or before Your Honor that relate to anyone appearing for deposition.
Yeah, I don't think I have any outstanding motions to compel anyone at this point in time. I think I took care of all of them.
I think that's right.
Okay.
We have everybody subpoenaed, Your Honor, and I don't have reason to believe that they won't appear yet, but if I come across that and we need the court's intervention, we'll file that forthwith.
Okay. Attorney Rosenberg, how many depositions does Ms. Reed have scheduled in the next month?
So we've taken, I believe, 6 and a portion. And then we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, at least 9, all scheduled within the current discovery period.
Okay. Attorney Daly?
Morning, Your Honor. For Waterfall, we have 3 depositions scheduled. We've been attending all the depositions as they've occurred, and we haven't encountered any problems yet with attendance or otherwise.
Okay.
I love the bars. The Waterfall's like, we're good. It's fine. It's just fine. It's all fine.
Attorney Holtzflag?
Good morning, Your Honor. We have 4 depositions scheduled for late July and August, and I too have not had any issues yet. In fact, counsel for certain parties have already reached out and been cooperative.
And that's for
Or I should say not parties, but deponents.
Okay, thank you. Is anyone considering filing a dispositive motion?
How many did CF McCarthy say they had? I'm going to back up just because I'm curious.
Say not parties, but
Should I say 4?
And I too have not had any issues yet.
I didn't go back far enough. Sorry, chat.
Good morning, Your Honor. We have 4 depositions
Okay.
scheduled for late July and August, and I too have not had any issues yet. In fact, counsel for certain parties have already reached out and been cooperative.
So to answer the question, what are the bars deposing on? The bars wanted to depose the blood draw experts. They wanted to depose the person who did the conversion of Karen Reed's blood serum conversion that we saw at the criminal trial, and then patrons of the bar. So that's where their focus is.
Okay.
Or I should say not parties, but deponents.
Okay, thank you. Is anyone considering filing a dispositive motion?
I would imagine so. Wait, I want to know where Rosenberg, where are we calling in from? I like the guitar. I have questions. I have questions about the guitar. Emily, are we just... Yes, the guitar's new. I'm just curious. So for those of you asking, what is a dispositive motion? Things like a motion for summary judgment that will dispose of a part of the case or a certain count or a certain party. I imagine that the bars will be filing dispositive motions.
Possibly.
Right.
Possibly.
But it's going to depend on how discovery bears out, of course, Your Honor.
Same goes for Waterfall, Your Honor. It's going to depend on how the depositions go.
Like motions for summary judgment, et cetera.
Yeah, we've been focusing on getting the depositions done, frankly, Your Honor. So I would say the same thing.
Okay.
We
All
can't
right,
know
well,
yet, Your Honor. We're not done yet.
Get back together on, say, August 6th. Are the depots scheduled that day?
Probably, but we can probably
Yeah.
split our time.
Yeah, same time, August 6th, 9:45 a.m.?
We have Waterfall.
Do you have a deposition scheduled today at 10?
We do not, Your Honor.
Yeah, no, we don't.
We did, but it's been taken off the calendar.
Right. Don't.
I selfishly,
They would have had one yesterday, Your Honor. 2 days ago, because this is from the 16th, but they would have had one on the 14th, but you didn't remove the stay until the 15th. So there's that.
The calendar.
Right.
I selfishly put them on at 9:45 when you have a 10 o'clock deposition, so it won't take so long. So let me know if they get canceled. Okay.
The court is literally like, hey guys, I put this here because say less, and these hearings can't go too long because you all are supposed to have a deposition. So please let me know when they get canceled so I can change this to another day so that we don't have time for things to wild out. It's not even funny because the day that things wilded out the most was when Diller wanted to air all the grievances. And the court's like, not yet, not now. There will be time for that later, and kept trying to cut him off. And he was just like, I have a prepared statement. Okay. It's not the lawyers who need to be brief, Your Honor.
Anything else anyone wants to bring up?
I just wanted guidance, Your Honor, on how the court wants us to address what we addressed at sidebar. Regarding the privileges.
I think the way, from what I read, it appeared that there was still some discussion going on. And it didn't appear to me that an end had been reached in those discussions. So if I am incorrect and an end has been met, then file a motion. And if an end has not been reached, then keep talking.
Will do, Your Honor.
All right. I just wanted, for purposes, we were just trying to accelerate given the short turnaround as it relates to the discovery.
I don't know how Diller talks so slow. He's probably never been yelled at a court reporter for talking too fast in his life. The opposite may be true. It's like the jurisdictions that have their speed limit signs, and they also have a don't go slower than sign. We need a don't go slower than sign. But when I have no idea what they're talking about vaguely with what we addressed at sidebar, and if we can't reach a conclusion, the court's like, right, then file it then. We have no idea what they talked about at sidebar and what the court wants them to file. But the inefficiencies that are just continuing to swirl here is just frustrating to watch. All right. So if you need to file something. Sure. Great.
Not been reached, then keep talking.
Will do, Your Honor.
All right. I just wanted, for purposes, we were just trying to accelerate given the short turnaround as it relates to.
Well, there's a whole lot of words. The Reed parties tried to accelerate a ruling on the stay with regard to Proctor, and the court reminded them in an endorsement order of the rules of 9A. So trying to accelerate things doesn't seem to be what Diller is naturally good at or what the court is inclined to do.
Will do, Your Honor.
All right. I just wanted, for purposes, we were just trying to accelerate given the short turnaround as it relates to the discovery period, to the extent that there is going to be discovery that's being withheld that we are entitled to. I appreciate we'll have those dialogues, Your Honor, but then my understanding was we were teeing that issue up to try to have some guidance on it so that if there's going to be further disclosures that are necessary pursuant to that disagreement that we raised at sidebar, it would happen timely so that we could use that data for depositions.
Okay. So Diller still is bringing up the issue that, teeing up the issue that there might not be enough time, and if there are additional disclosures, and this is how we're ending up. I'm sorry, as it relates to, did I word salad it enough or no? Or yes or no? Did we word salad it enough? Maybe. But when we're looking, now I can't stop. Emily, leave the bit alone. It's not a bit, leave the bit alone. This is where we're ending up with everybody wanting their depositions to be at the end. Because you already hear what Diller's starting to say. Hey, but if there's more information, we want that information for deposition. So if we don't have that information yet, we want the deposition to go later, but we're running up against this deadline. And so there's a push-pull of wanting to push the depositions to the kind of end to make sure that they have the things they want before the depositions. This is not just a Diller problem. This is why Reed's team was in arguing over what was going to happen with the documents getting turned over from Colin Albert, because they wanted the documents before they did the deposition. This is both sides trying to have all the information they need before the depositions. But Diller's also being vague in, we kind of talked about this at sidebar, but if we need more time, there's going to be more disclosures, and then we need this before we get to the deposition. Okay.
Disagreement that we raised at sidebar, it would happen timely so that we could use that data for depositions.
Your Honor, if just very briefly, what we're talking about right now is the form of the privilege log. These are privileges that we made, objections we made in October of last year. So I'm happy to speak with Mr. Diller right now at the end of this conference and find out what exactly he thinks he needs and try to get it to him.
Really? Rosenberg's just like, what are we talking about? Fantastic.
It happened timely so that we could use that data for depositions.
Your Honor, if just very briefly, what we're talking about right now is the form of the privilege log. These are privileges that we made, objections we made in October of last year. So I'm happy to speak with Mr. Diller right now at the end of this conference and find out what exactly he thinks he needs and try to get it to him. That's what I...
All right, so if everyone's willing, whoever needs to is willing to keep talking, that's great. And as far as teeing it up, I didn't anticipate it in our discussion that I gave an indication that we needed to have it done by today. But I understand the time issues, and if it gets to a point where you think it rises to the level of an emergency, I don't really know how it could, but you have the rules that you can avail yourself of and get the matter before me.
Okay, thank you, Your Honor.
Okay. Thank you, everyone.
The court. Why do they keep filing so many motions? Also, the court. You know you can just file a motion. Right. And then they file motions and you're just like, ah! All right, so what did we learn from Rosenberg's response to Diller saying, that thing over there wheretofore we discussed the issue that we are not at a conclusion for that we were discussing? And Rosenberg's like, right, so we're talking about the privilege log and the form of the privilege log. We asserted the privileges. You have to have a... this is the document or answer or thing. This is the thing. This is the privilege that's being asserted. And Rosenberg's like, right, we're talking about the format of the privilege log. And the court's like, fine. Can you just sort it out? And I don't even know what the fight is over the format of the privilege log. Can we all just agree on 12-point font and make it a PDF that's searchable? Can we just, what are we doing? Get the privilege log turned over. But also, it's Diller, the way that Diller talks about things and the vagueness of it makes it seem like it's a very big deal. And I appreciate Rosenberg coming in and being like, so right, the privilege log, we're still talking, right. We're trying to come to a conclusion on that. And maybe my perception of this is wrong, but it seems like Diller brings issues to the court and Rosenberg's like, we could have just had this conversation, but you want to have it with a mediator. Could we just have a conversation after court about the format or whatever? Could we just do that, please? All right. So it sounds like they're wrapping up this hearing. It's fine.
Avail yourself of and get the matter before me.
The judge, if you need to file motions, just file them. It's fine. Also, look at how many motions you filed.
If it gets to a point where you think it rises to the level of an emergency, I don't really know how it could, but you have the rules that you can avail yourself of and get the matter before me.
Okay, thank you, Your Honor.
Okay.
Does anything get resolved
Thank
by
you,
bringing
everyone.
it before the court?
Have a nice day.
You too.
Thank you, Your Honor.
Okay,
All right.
so just for the record, the matter continued to August 6th, 2026 at 9:45 a.m. For further status, that hearing will be held via Zoom. Thank you all.
Did she say 9:45? I think she said 9:45. Yeah, 9:45.
Okay, so just for the record, the matter continued to August 6th, 2026 at 9:45 a.m. For further status, that hearing will be held via Zoom. Thank you all.
All right. And that's the end of that. Where's my gavel? Fantastic. It's the end. All right. Well, the status conference resulted in everyone saying that they have done numerous depositions. Here, let me make sure nothing auto plays. And I wrote this date down. August 6th at 9:45 a.m. is the next status conference. It doesn't mean there won't be other things that come up in this case, but August 6th, 2026 at 9:45 a.m., the attorneys all indicated that they have numerous depositions scheduled, that they don't see any immediate issues with people attending their depositions. A number of you asked, Emily, but where do we stand on Colin Albert's deposition? Well, when we left that hearing and saw the court's orders, the court kept asking for more information from the lawyers. So that is kind of floating out there, waiting for more information for the lawyers to figure out how they are going to do that. That issue is resolved and that it's in progress, but it's not resolved as to when Colin Albert will be taking a deposition. The court did make orders about what documents needed to be turned over there. We also don't know when former Trooper Michael Proctor's next deposition will be going forward. I imagine that we won't know, when that deposition will go forward. I imagine that the date will be kept quiet on that unless it comes up in filings, but it seems that that has been a contention. We heard from plaintiff's counsel Diller that the plaintiffs have taken 12 depositions. We heard from defense counsel, I'm just going to refer back to my notes lest I forget the exact number, but we heard from defense counsel, Reed's attorney, that they have taken 6.5 depositions because the Proctor deposition is incomplete. It is in progress. It is ongoing. And then we heard that the Waterfall and CF McCarthy's each have a few depositions that they are waiting to complete. The Waterfall with 3, CF McCarthy's with 4. So there are depositions that need to happen. But what happens when the discovery closes? And we heard the court ask about this in the status conference. Once discovery closes, then they are going to move to dispositive motions, like motions for summary judgment. I imagine that there will be quite thorough motions for summary judgment, especially as to CF McCarthy's and the Waterfall. That's an opportunity for them to have themselves removed from the case before it goes to trial. And I think from Reed's team, they will try to narrow down the counts or the claims being brought against Karen Reed. So the dispositive motions can dispose of an entire part of the case and narrow down the issues before trial. In my work as a research attorney in civil, there were times I received motions for summary judgment in bankers' boxes with deposition transcripts and what have you. Those can be almost like a trial on the depositions where the court is deciding there's no way this can go forward. We saw that to some effect in the TikTok psychic case, where on motion for summary judgment, the court decided liability on the issue of defamation, and then the trial only went forward on the issue of damages. So those dispositive motions are things that can really change what a case looks like going to a jury, and that is going to be, I expect, quite thorough litigation, and those generally are quite extensive motions with lots of exhibits and quite substantial court hearings on them, but we're not there yet. It is much more thorough than the early on motions to dismiss or the early on like anti-SLAPP motions and things like that, because those all happen before discovery. These are things that are happening. I said that very weird. These are things that are happening after discovery. And so before this ever gets to trial and after discovery closes, we will have all of those motions that we will be going through, because this is the litigation that never ends. It just goes on and on, my friends. And it is all so interwoven that I don't think we can well cover like Karen Reed suing everybody without covering this. And we still have a whole bunch of litigation to jump into in the defamation case that we just haven't got to yet. And we're going to do that, not today, but we're going to do that next week, because there are early motions happening over in that case. And there's a hearing as to those motions. But I didn't want to cover the hearing until we covered the filings of the motions. And there's quite a lot of filings. So we'll be covering the defamation case going into next week, if that makes sense. But yeah, this is an extensive amount of litigation, and it just starts to weave into each other. And it will also be interesting to issue spot where we might have issues of like equitable estoppel and judicial estoppel. We might have these issues coming up because in some cases, the third parties are actual parties And so we have all these parties positioned kind of differently to each other in different cases. And we might end up with some of those interesting arguments where you can't argue one thing in one court and one thing in another court. So it actually might be quite interesting. So we'll see. But it feels like a lot because it's so much litigation. That will be back in court on August 6th. We are running up to that discovery deadline. Chat, just tell me in the chat, who's going to be the first person to ask for an extension of discovery? Is it going to be plaintiffs or is it going to be defendant Reed? You let me know what you think. It's definitely not going to be CF McCarthy's and the Waterfall. So is it plaintiffs or defendant Reed? Who's going to ask for more time on discovery first? You let me know what you think in the chat. And I am just going to double check the docket, make sure no new dates have popped up. And then we are going to get to questions. That's what we're doing today. And then I have a bunch of like business office stuff that I have to do today. So don't let me procrastinate too long, chat. Emily, but you're looking up new documents. I mean, it doesn't mean there are any. I'm just curious. The docket I've been stalking the most rigorously has been Richens, because I want to know what the court is going to do with regard to whether a new judge needs to consider that motion. And I can't stop looking. I want to know immediately. Most of you think plaintiffs are going to be asking for an extension first. Yeah, I agree with that. I think we will see Diller. He's been teeing up that issue for months now. And I think it's interesting because normally delay hinders plaintiffs more, but it seems like plaintiffs are really the ones that at times are pumping the brakes here, which is unusual to me because it's just outside of the norm. So no new dates have popped up on the docket. So August 6th remains the date. If new dates pop up on the docket, I'll let you know. And nothing else from the hearing on the 16th. All is quiet on the docket. Leonard's, look here, I'll just put the docket up so you can see it. All is quiet on the docket, which is why I pull things up. So, you don't have to take my word for it. You can just take a look yourself. All's quiet on the docket for now. Shh. We're at a good stopping place on the docket for the Karen Reed wrongful death case. Now we have lots to do on the defamation docket. We will do that a different day. It's 5 o'clock and all's well. Good. But also it's like walking into an ER and being like, hey, it's been real quiet today. Shut up. What are you saying? Don't ever say that. So we're going to pretend we didn't just say that. We don't want to jinx it. And we'll see what happens between now and then, but lots going on in the other cases. As I said, we'll get to that next week. So don't forget to get the Leonard app so you stay in the loop. Let's get to questions real quick. Angie said, did we cover the cell phone hearing, AJ's hearing from last week? We did. We covered it last week. Ferry said, EDB, do we have a general timeline for when we get a response for the phone problems? No, because I think they are waiting on an order from the court, and courts take the amount of time that they take. So we just have to wait and see. So Leonard, let's get to questions. You've got questions. I've got questions. We've got questions. We've got questions, lots of questions. So let's have a chat, shall we? It's time to chat. Tori Amethyst in the chat said, not the Q word, right? Never, ever, ever. Exactly. Oh, it's been so calm. No, don't ever say it's calm. I also promised you a gong story because we were talking about comma, chameleon. Yeah. Comma. We were talking about that. So I was walking off the field. I think it was at the Whitewater show for the Cavaliers. And I was walking off the field with their tour manager, who has to have like the most difficult job in the world. And he's helping push equipment off the field, including the gong. I think there are 2 gongs in their show, but including the gong. And he's like, gong coming through. And I'm like, opportunity missed to just say that gong, 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 gong. So then we both started singing the gong song. And a number of the younger marchers just kind of looked at us, and I was like, wait, is 2026 the year where y'all don't know what I'm talking about? Have we gotten to the point where I made a thong song joke and some of you have no idea what I'm talking about? Crap. And that's what it was. That's what it was. Some of them were just like, huh? He and I had quite a chuckle, but there were either that or they were like, we have sweat out 7 gallons of water and now I have to push all of the front ensemble up a hill, keep it from rolling away from you down a hill, which actually getting the front ensemble instruments, getting the marimbas and stuff down the hill actually seemed more challenging. I don't know if it is. Front ensemble, I could never. But like they had to get off the field after performing their entire show, up a hill, down a hill, up another hill, down a very big hill. And the way they were holding on to their instruments and just leaning back to try to keep them from taking off was terrifying. It looks so hard. It looks so freaking difficult. And I'm like, it might just be that like after performing an entire show, that trying to get the instruments back to load is also just exhausting. And they're not here for my cheeky ass being like, that gong, 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 gong. I thought it was hilarious. I didn't have to perform an entire show. I was not also trying to keep a marimba from going down the entirety of the hill because it's so hilly. Literally up the hill. I'm not being hyperbolic. Off the field, up a hill, down a hill, up a hill, down a massive hill. And then the trailers. It was crazy. Just hauling them back down was just wild. And, you know, heavy things downhill when you're tired seems really stressful. So, questions. All of the questions. A lot of you are like, EDB, is this it for this is it for today? Because we do not have time to cover all of the stuff going on in the defamation case. EDB has some meetings that she has to get to because there's also worky things happening, which is very exciting. But it's not exciting when we have all the meetings. It's really exciting when I get to share it with y'all. So it's exciting. It's exciting. And we're just going to answer some questions and then we'll go from there. So thank you everyone for the 10 gifted memberships. We've also reached the end of the day where apparently Emily can't talk. Jen, thank you for the 10 gifted memberships. Sarah, thank you for the 10 gifted memberships. And everyone who gifted memberships, thank you and welcome to all our new law nerds. I know earlier I said, gird your loins. I always make the reference back to, well, in my brain, it's just a reference back to The Devil Wears Prada, though that is not where the reference begins. But I saw a couple of you asking about that. The other Emily said, EDB, you should watch the defamation case. We'll get there. We're not there yet, but we will get there. Don't worry. I want to go through the motions and we just haven't had time to do all of it. But truly, vacating an order in a footnote? Like, what are we doing? What are we doing? It's just, what are we doing? It's wild. I appreciate Zeke, Texas NP said, let's eat mom versus let's eat mom. Exactly. The commas matter. It's a very eats, shoots, and leaves kind of a problem. But the problem is that this litigation has already gotten so contentious that trying to do sentence construction seems unnecessary when I think the court could just be more clear about what they want. Yeah. Yes. This is a great question. Nicole the Kiwi said, so what is the footnote actually for? I've thought it was for references. It generally is for references. However, we've seen it in this case being used for like a PS for additional information that is context. So we've seen the parties use it for context, not just for reference. So it has been used for added context, but I don't think vacating an order is added context, do you? I really don't. So we'll see. Chat Mom said, can't they bring the trucks closer to the field? No, they can't. At many of the fields, they cannot, because all the marchers are going back and forth. And so you can't have the vehicles blocking the field because they have a very short period of time to transition. One corps is marching onto the field while the other corps is transitioning off the field. And the only way you can keep that running is if you have a staging area that is free, and you cannot have a staging area free with all the trucks in the staging area. So no, the trailers are generally fairly far away, but it's just whether it's flat or whether it's hilly, though there is a gator that takes the timpanis, because pushing the timpanis around seems like a terrible situation, but there is a gator for the timpanis. Everything else gets pushed on wheels. But they are very strong. And at the end of the season, they are all very tan and very buff. Though they are tan except for hands, feet, and then the drumline has always very interesting tan lines. So yeah, it just is a thing, but they're also prepared for it. I'm just looking at it going, oh, that seems hard. Like at the end of water polo games, you're just kind of throwing balls in like a mesh bag so that the water can drain out, and grabbing everybody's caps and then taking a shower and taking off a swimsuit. Like there was way less equipment to deal with. So, and I didn't do this type of competition when I was in band. We also didn't have 7 different kinds of equipment on guard. We had like the one flag, and that was about it. Maybe a swing flag if we were sassy, but it was not nearly this. This is very cool though. And I love seeing it. Let's see. Super Coffee Gal said, how has it been 4 years? I don't know. Time is just a vortex at this point. It's wild. Heaps of Sleeps says, the judge, the next hearing, finished your depots yet? That's 100% what he's going to say. How many depots have you gotten done? Do you have any more left? That's exactly what's going to happen. For sure. Polar Bear said, can't they get a different judge? Not easily. And nobody's asked. Also, the attorneys might truly look at the judge that they have and the other judges that are the option and think that sometimes you're better with the judge that you know. And so there are some decisions in that, but no, it's not easy when you are this far down the road to switch judges in a case, and they've not asked to do that. I will be interested to see what happens from here, but no, they have not asked for that at this point. But I think the discovery deadline is probably going to get extended, or at least extended as to certain things. I can't see the judge cutting off the discovery deadline as to Colin Albert, given everything that's gone on. I think the judge will say, okay, as to this deposition, it can continue. So I think the court might narrowly tailor a remedy as to certain things, saying these things need to be finished up, but we'll see. It's much. Music to My Soul said EDB basically a footnote of first impression. I mean, first impression for me, for sure, because what are we doing? Richard the Magician, this is a great question. Richard asked, what exactly qualifies as a sanction from the court? I thought it was just an order to pay money. There can be a lot of sanctions from the court, including discovery sanctions. So we saw a discovery sanction in the Rust case as to Alec Baldwin. My brain just like stopped, and it's fun when brains make the association, and my brain was like, the Backdraft case? No, Emily, not Backdraft. Alec Baldwin. I don't even think that was Alec Baldwin in Backdraft. I think that was his brother. Either way, Alec Baldwin in the Rust case, the discovery sanction for the prosecution's discovery violation was dismissing the case. That's a discovery sanction, but it's not a monetary sanction. So when there is a remedy for something, that can be a sanction. It's not just sanctions of money. We have seen in other cases, though I did not cover it, I believe it was Lori Vallow's case, where as a discovery sanction, the court removed the death penalty as an option in that case. And so we have seen discovery sanctions that can be non-monetary. The court said that staying discovery as a proctor wasn't a sanction. I think the attorneys feel differently because it is an action of the court that impedes them in some way or changes something that they're doing. So I think you can look at staying discovery as a sanction for behavior. And where Reed's attorneys took issue with that is that they were not giving an opportunity to be confronted with what was allegedly done, to respond to it. And the court didn't say it was them, but the court said, because this thing happened, or because I think, this is more clear, because I think this thing happened, I'm going to stay discovery as to Trooper Proctor. Reed's team said, well, that impacts us the most because we're the ones that need to finish the deposition of Trooper Proctor. We are the ones who are seeking that discovery. That's a witness that we want. So you are sanctioning us without giving us any opportunity to be heard, which is why we saw that note in the filings today that, hey, if the court thinks there's a violation, can you let us respond? So sanctions do not just have to be monetary sanctions. And we've seen that in different cases, including civil cases where we've seen different types of sanctions where the court can actually, and the court in this case on July 1st at that hearing said that these sanctions may include like monetary sanctions, contempt, dismissal of the case, or even just denying the ability to bring a defense in default. So you can have a number of different types of sanctions. I'm glad you asked the question because I'm sure others had the same question. It's fantastic. D asked, will you cover the Jared Bridgen case this fall? I don't know what that case is, so I cannot tell you. RK said, front ensemble former mama here. Gotta keep tight rein on the mallets and the synth cart. The synth cart looks really heavy. And the Cavaliers are using their synth in such a cool way this year. I really love it. I'm completely biased. I really love their show. It's always more fun to see your kid perform in a show that you absolutely love. There are times if you do not love a show where you're like, I love my child. I really love my child. I love my child. I love my child. But this show is not my favorite. And that's okay too, because I'm not the judges. So it doesn't really matter what I think. I appreciate being delighted, and I really am delighted by the Lost Boys show this year. Virginia, thank you for the 10 gifted memberships. Him Goblin said he may goblin, he may not. Leonard Bag. I mean, that's kind of where we're at the moment, right? We're not quite sure, but chaos goblining is happening. Gray Space said he's an itemized list of 30 years of disagreements. Yes, you have to be more specific. Here are the disagreements. Randy in the chat said, loving all the pictures of T. Me too. He's had some really cool action shots this year, and I love seeing it. He gets to do some really cool stuff in this show, and it's fun to see. User said Colin had time to interview with Gretchen Voss. I haven't seen that. And do we know when it was done? Because I know that there are times when articles come out that those can be done well in advance. I'm curious. So we'll see. Gemini said, Emily, I believe Reed's legal team should file an interlocutory appeal. Reed's legal team has enough lawyers to figure out both what they're capable of doing and the strategy of it. I don't know if it would help given the amount of litigation they have going on. And for those of you that are like, EDB, what's an interlocutory appeal? An appeal that happens in the middle of the case, not at the end. So kind of in medias res. It's as it's happening, and you can stay things for that appeal. Corey Richens tried it a couple times and they were denied. I also do not know in Massachusetts what the likelihood of that succeeding is. And if it doesn't succeed, it might just make things, well, a whole lot worse. Elizabeth Stanley in the chat said, my cousin's husband is the head of brass for the Blue Stars. Their brass scores have been great this year, and they are like hot on Phantom Regiment's tail. I'm sure they are absolutely thrilled. They keep just getting higher scores than the Cavaliers.
I have no salt, a little bit, but their brass scores have been incredible. They've been having a really, really great season, and I'm sure they are absolutely thrilled because it's a really interesting field this year, and you can see the cores continuing to push, and now we're going to start seeing the show starting to shift. It's just a really interesting time of year to take a step back and watch everything that's happening and watch the competition amongst the cores. It's really fun. So I love seeing it. I love seeing it. Of course, I'm shamelessly rooting for my kids' core, but I also love seeing what everybody's putting on the field. It's truly exciting. Rex said a tiny grain of salt, just a little bit. But look, at the end of the day, the fact that you still have in 2026 enough kids to fill up this many cores who are excited to undergo what it is to be on tour like this, the mental and physical difficulty of a tour, to continue to put music on the field in untenable sometimes conditions, to sleep on a gym room floor or in an auditorium, which is what Travis sent me a picture of this morning, was the auditorium. I'll see if I can pull that up and show you guys, but on an auditorium floor where the auditorium's like slanted, so you're kind of like wedged in between the seats so you don't like roll down, to be on buses at all hours of the night, to, roll into a housing site at 5 a.m. with no hot water and just be like, well, I guess that's what we're doing tonight. And really to spend an entire summer just dedicating themselves to doing something that is incredibly difficult for the love of the game. And that it is something that you still see, even though we talk a lot about, especially our teens and young adults, and are they on phones too much, and are they on social media too much, and has the ability to just ask whatever device or thing to answer questions for them. Has that changed their attention span, their grit, their tenacity? And when it comes to kids who are doing DCI, kids, and I think this extends to kids who are doing performing arts in any way, and extends to kids who are focused on any type of endeavor, whether it's theater, music, athletics, whatever, they are putting themselves, I think, in a position where they are choosing to do hard things in a time where immediacy and challenge and discomfort are starting to disappear. And it's wonderful to see that there are so many that are saying, this is hard and it's hot and it's fucking amazing. Like, oh my God, it sucks. I love it. Like, that feeling is something that there's few places you can really find anymore. And I love seeing that so many are willing to like rise to the challenge. I think it's a great thing. And to see them just really be like, no, I'm not going to be on a phone all summer. I'm not going to be on social media all summer. I'm not going to be on tech all summer. I'm going to be in buses with a bunch of other sweaty teens and well, up to 21 teens and other teens. I'm going to work my ass off. We are going to put something amazing on the field, and it is going to be hard and great. And there are going to be moments where it is challenging and you are going to learn a different level of grit. And I love it. And I love seeing it. And so when I'm shamelessly rooting for my kids' core, but I'm so just encouraged by all the cores and all the work that goes into it. I love it. I think it's great. It's incredible. So I love seeing it. And I also love seeing that, though we see a lot, especially if you're online, we see a lot of taking shots at our young people particularly, and how much they are on phones or social media or relying on AI or whatever the conversation is, that they're not talking to each other. And that's the opposite of what I'm seeing when I'm out with the cores in the summer. I'm so encouraged by that. I love seeing that these are not, I don't want to say kids, but they are, to me, they're kids. Like, you're under 21, you're kids. They are not unable to speak with one another. I was watching T chatting with his corps, but also kids from another corps came up, troopers, and had a hacky sack. And they were all just standing around hacky sacking and chatting after the show. They are able to talk to one another in a way that, well, they know each other because they're in corps, but they don't know each other. And so it gives me a lot of hope and encouragement. And it's incredible to see. But I also love that hacky sacks are kind of back. Like, I love it. So it was really fun to see some of the Troopers Corps members like pop on over to where the Cavaliers were staging and be like, we have a hacky sack. Anybody want to play? And they just got a circle together of kids and we're just hacky sacking and chatting about their shows. They are building lifelong connections in a different way, and in a way that I don't think is often represented in the way that our young humans are always talked about. So I'm encouraged, and I'm always just a little bit in awe of, choosing the suck because you love it. It's great. And I get it. So I enjoy it. And it brings me a bit of hope, truly, because sometimes that's a little missing. Not for me. I'm very emo about it, but it just brings me a lot of hope because we have quite a lot of kids who are just willing to get out and meet each other in person and are starting to push back on just connecting over digital devices. And I think that's a good thing too, that they can do both. And I love seeing that they're finding a balance for both. And that's encouraging. I really enjoy it. So that's where we're at. Mars kept saying, we taught our sons to play jacket sack and they play at swim meets and practices. It's so fun. It is. And it's, what I love? The thing I love about the hacky sack is that it brings back a little bit of like when you're watching like 5-year-olds play, how they just like walk up to each other and they're like, want to play? Like, hey, can we just play? Oh, you have a shovel. I have a bucket. Can we just play? The hacky sacks kind of bring back a little bit of like, I have a thing, want to play? And it bridges that conversation in a really cool way of like, hey, we can just chat and hacky sack. I absolutely love it. And it brings back a really nice kind of icebreaker without calling it an icebreaker. But I dig it. So it's really fun to see. And I'm excited and I'm encouraged and I love watching it. I do. I think it's great for kids to push themselves and to find ways to push their own limits and to find that friction in resilience, because if you can do a summer on tour, you can basically do anything. Like nothing is going to be as hard. And I think that's a gift when you are in your late teens, early 20s to meet challenges where you're like, I don't know if I'm ever going to face anything this hard again, because adult life will feel hard, but you can always look back on that thing and be like, but I did that. Like if I did that, I can do this. And I think that's a gift. And I don't know if people have enough opportunity to like challenge themselves in that way. And it's cool. And it's a blessing to have the opportunity to do that. I'm going to see if I can find this video for you when I talk. Oh, I think this has some copyrighted music in it. Yeah, it's going to be fine. I'm going to show you what I mean. And there's no faces in it, so it's going to be fine. I didn't ask Travis permission, but it's going to be fine. There's no faces. As I show you a little bit of what waking up in the morning looks like on tour, because again, perspective, because it's crazy. All right, let's just pull that up real quick. I'm going to turn this down a little bit because there is, in fact, copyrighted music because they were waking up this morning to, well, it's different music every day, which I also love. All right. So this is the morning wake up in the auditorium. I was not joking when I said they were sleeping in the auditorium. Yep. Sleeping in the auditorium. Emily, what's that whirring noise? Air mattresses.
Emily, why are the air mattresses going with the music? I think they were breaking down to get ready to leave. But yes, when I said that they were sleeping in an auditorium, they are sleeping in an auditorium all over the place. So yes, that's a whole thing. That's the entirety of the auditorium. And then everybody got to shower. And then let me tell you how clean they leave these schools. Because everyone on staff is like, hey guys, we love this housing site. Do not fuck it up. Everything will be spotless. Everything will be spotless. And they make sure that they have tied up their trash bags, that they have all left them together. They clean up everything because they love their housing sites. And for those of you that have high schools or universities that serve as housing sites in your area, you know that you can go and watch their open practices. And it's also the Corps love being at their housing sites. And I think the housing sites love having them there. It's just such a cool thing. So that is their, you've got people sleeping in the aisles, sleeping in between the seats, just everywhere. Mm-hmm. Some people were sleeping on stage, but Mr. Matson in the chat said, leave the site cleaner than when you arrived. 100%. And they change wake up songs every day. So that's a little peek behind the scenes of tour. Charlene said, clean like Japanese football team leaves the locker room. Exactly like that. Leave it better than it was. So with that, Law Nerds, it was great to see you. I don't even know how to explain the journey that we're on in this case now, because I can't look away. I feel like we're like 4 seasons too long on a TV show that used to be good. And now we're all just sitting here blinking going, huh? Like, what are we doing? We've jumped the shark, but we're still here. We're still here. Sure, it's not a stupid question. DCI is co-ed. The Cavaliers are not. The Cavaliers are the only all-male corps that still marches. But yes, the corps are co-ed. Some of those are stories for another day because, if you ever know anyone that marched, ask them about their tour stories. Those are not always my story to share. Tour stories are a lot of fun, but yes, most of them are. The Cavaliers is not, but so yes, most of them are. And what else? With that, be well, Law Nerds. EDB is going to get some other work done because Team Baker has lots of stuff we want to bring you in the coming months. And that means EDB needs to get her work done. So thank you. We will be doing some more Karen Reed stuff next week because we have lots of stuff to do in the defamation case. I think there are other things that we also are going to look at next week. I am going to summarize the David case on the podcast. I will keep you posted when I am going to record for the members. I think that will be Saturday. That is my goal. But I will keep you posted on the David preliminary hearing on the podcast. As I said, we will not be going into every single detail of the things. We will be overviewing them because I think that, that's my comfort level with the case. But also, I know a lot of you want to be kept in the loop of what's going on with the David case, but also would like to be able to sleep and send your children out into the world in the future. And I understand that because it is a really difficult, really disturbing case. And then we will get into streaming next week. So I will see you all over the weekend. I will see you next week. Take care. You will see me popping up on Instagram because I still have a fleet of stuff I want to organize and share with you. Just other stuff keeps popping off. But that's okay. Thank you, Team Baker. Thank you, Law Nerds. It's good to see all of you. Great to have a little bit of a chat. Take care of yourselves. Take care of each other. Have a good weekend. Hope the weather is not spicy. And I will see you soon. You guys are the best. Have a good one. All right. Bye, everybody.
Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.